Your Lordship, Rose, you had referred to CJAR, the Campaign on Judicial Accountability. That arose in a slightly different context, where a two-judge bench had said that the matter should be heard by the first 5 judges of the court, designating who those individuals will be. So when it went before the Constitutional Bench, which is, I'll give you a lot of the citations, 2018, 1 SCC 196. After noting that the Chief Justice is the head of the roster, master of the roster, etc., they say, needless to say, this para 7, needless to say, neither a two-judge bench nor a three-judge bench can allocate the matter to themselves or direct the composition for constitution of a bench. To elaborate, there cannot be any direction to the Chief Justice of India as to who shall be sitting on the bench or who shall take up the matter, as that touches the composition of the bench. We reiterate such an order cannot be passed. It is not countenance in law and not permissible. So it is in that context. So this I think is well said. There's no doubt.
I qualified it in a somewhat different context.
Your Lordship has noted. So your Lordship are right that with reference to individual composition, who the judge will be, of course, there's no doubt about that. Now we are on numbers.
Beyond saying that it should be heard by a lawyer.
Correct. No, much beyond this. Direct invasion of the
CJ's powers.
Correct. So that of course is no doubt. We are here on numbers. So on numbers can a court designate. Now, there seems to have been no judgment that we can find where this question has arisen about numerical determination of a bench of smaller quorum. Now, sometimes there may be a situation, and just because we are looking at it academically, sometimes there may be a situation where you have 2 constitutional bench judgments binding on logic, or 2-3 judge decisions binding on logic. In which case, it may not be improper. I am saying this to myself. May not be improper for your Lordship to say, look, there's 3 and there's 3. I don't know which binds me. So let's go to 5 for that to be reconciled. That may be a question which may arise. But Dawoodi seems to suggest no. You still have to send it to 3. 3 will decide what the conflict is, whether the conflict lies, and then send it to 5. That ladder has to go step by step, is the implication. Which brings me to the second question. Then, if you want to have my note, there appears to be ambiguity. The nature of exceptions carved out for reference by a lesser quorum to a larger bench, as the exceptions contained in para 12.3 of Dawoodi has to be reconciled with that in para 7 of Parija, to the extent that Article 145.3 is to be interpreted. Both these judgments are of 5 judges, but do not deal with a situation where an existing binding judgment has already been rendered. If your Lordship will turn the page, we have extracted both of these, so if your Lordship can just see that. Parija's para 6 and 7 on the second page. Bottom of the second page, para 6 of Parija. In the present case, the bench of 2 learned judges has in terms doubted the correctness of a decision of a bench of 3 learned judges. They have therefore referred the matter directly to a bench of 5 judges. In our view, judicial discipline and propriety demands that a bench of 2 learned judges should follow a decision of a bench of 3 learned judges. But if a bench of 2 learned judges concludes that an earlier judgment of 3 learned judges is so very incorrect that in no circumstances can it be followed, the proper course for it to adopt is to refer the matter before it to a bench of 3 learned judges, setting out, as has been done here, the reasons why it could not agree with the earlier judgment. If then the bench of 3 learned judges also comes to the conclusion that the earlier judgment of a bench of 3 learned judges is incorrect, reference to a bench of 5 learned judges is justified. It is not necessary for us to go into the hypothetical cases spoken of by counsel for the appellants, where a reference directly by a bench of 2 learned judges to a constitutional bench would be justified. Suffice it to say that for the present, we find it very difficult to accept the correctness of such hypothesis. The only situation when a 2-judge bench may refer matter directly to constitutional bench is when the provisions clause 3 of Article 145 are attractive. Now, this is the exception that has been carved out, where 2 can directly send it to a constitutional bench. Now, please see in Dawoodi, the Dawoodi exceptions at the bottom of this page. This para 12, sub para 3. Same page, we've just taken out those paras. The above rules are subject to 2 exceptions. The above said rules do not bind the discretion of the Chief Justice in whom vests the power of framing the roster and who can direct any particular matter to be placed for hearing before any particular bench of any strength. And two, in spite of the rules laid down here and above, if the matter has already come up for hearing before a bench of larger quorum, and that bench itself feels that the view of the law taken by a bench of lesser quorum, which view is in doubt, needs correction or reconsideration, then by way of exception, not as a rule, and for reasons it may proceed to hear the case and examine the correctness of the previous decision. So, this is an exception to 2, the para above. A bench of lesser quorum cannot doubt the correctness of the view of the law taken by a bench of larger quorum. In case of doubt, all that the bench of lesser quorum can do is to invite the attention of the Chief Justice and request for the matter being placed for hearing before a bench of larger quorum, then the bench whose decision has come up for consideration.
So this we can do if
there's a doubt.
If there is a doubt, we can follow this. This is what is
the
Lala Bhagwan saying.
The problem I perceive is twofold. First, when you have
but this is a binding judgment.
Both are binding judgment. So is Parija. Now,
Right,
Parija
has now been considered by Daudi.
But no.
Parija was considered by Hansoli Devi.
Referred. There's a whole bunch. There are 3 judgments after Parija. All 3 judgments which are referred to.
And then this is finally expressed.
Correct. But without agreeing or disagreeing with Parija.
No. If suppose we disagree, we can say that in terms of Daudi, because what Daudi
that's the problem.
Is what Justice Gajendra Gadkar suggested for the High Court.
I agree. So here's the problem. Forget the irony that 5 judges who are laying down what precedent should be have decided to consider a 5 judge and then not say anything about it. So here's what the doubt creeps in. If Parija says when you have a doubt, refer to 3. Parija doesn't say go to the Chief Justice. Parija says refer to 3. Dawoodi says when in doubt, send it to the Chief Justice. Now, how do we reconcile this? These are 2 binding judgments. Dawoodi doesn't distance himself from Parija at all. Second problem, Parija opens the door to a 2-judge bench, like this bench at the moment, and says, if a 145.3 issue arises, send it directly to the Constitution. That's the one exception it talks of. Dawoodi talks of no such exception. Now, if Dawoodi has noticed Parija, which it has referred to it, surely that should have been inserted here. How do these 2 principles stand side by side?
No, but what is the principle? If an earlier judgment and a later judgment express divergent views,
correct,
but the later judgment considers the earlier judgment,
correct,
it is the later judgment that will prevail.
But the later judgment has to be of a larger bench then. It can't be of the same size.
No, it may not be.
No, you can't. That's the principle. This is like
them. Being in a combination of 2, which one do we follow? Do we follow Parija or do we follow Dawoodi?
I say refer it to 7. I say Chief Justice should look at this issue and have 7 judges consider this issue in full. Because to my mind, I can't find a way to reconcile these 2. Either they both exist and they run on parallel tracks. In which case you have 2 exceptions plus 1 exception. You have 1 point of guidance plus 3 points of guidance. You read it as a whole. Let's of course ignore the fact that neither Islamic nor Inamdar followed either of these.
No, but the distinguishing factor can be that in Parija,
yes,
when they are laying down the norm, they are dealing with a 2 judges bench, dealing with a 3 judges bench.
Yes.
Right?
Yes.
Here, it can be a constitutional bench judgment also for a 2 judges.
Could be.
So therefore, it need not go to 3. Therefore,
No. Parija makes it clear. Parija says
if it's covered by 145.3, if it's a constitutional.
That's the only exception. That's the only
constitutional.
Now, that brings me squarely to question number 3. Which brings me to question number 3, which is the further area of doubt. In any event, as 145.3 is a constitutional mandate, in this limited context of 145.3, whether a lesser quorum may indicate the numerical strength of the constitutional bench may be examined. Whether a bench of lesser quorum, 2 or 3 judges, can indicate a numerical strength of 5 or more judges while referring the case to the Chief Justice of India under 145.3. Because in my view, I have no doubt that 145.3 is a constitutional mandate. It's not constitutional benches deciding. It's a constitutional mandate. Let me just read that to you. It's to top of the note, but in any event, the minimum number of judges, this minimum number was, I think, by earlier it said subject to provisions of 144A. 144A is no longer there. So the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution, or for the purpose of hearing any reference under 143, shall be 5. Provided that when the court hearing an appeal under any of the provisions of this chapter, your lordship are hearing appeals right now because leave has been granted. Under any of the provisions of this chapter other than 132 consists of less than 5 judges, and in the course of the hearing of the appeal, the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this constitution, the determination of which is necessary for the disposal of the appeal, such court shall refer the question for opinion to a court constituted as required by this clause for the purpose of deciding any case involving such a question, and then shall on receipt of the opinion dispose of the appeal in conformity. So the questions will be framed here. It will be referred to at least 5 judges.
No, but it says that involves a substantial question of law.
Of
That means,
interpretation of the constitution.
arising from the facts of the appeal.
Correct.
But here,
Yes.
we are not perhaps doing that.
So
We are doubting whether it is covered by the provision.
that depends on how the question is framed. So if the question is framed as has been answered by Pramati, it's answered. But if it is a question that has not been answered by Pramati, which the way I see it, specifically, Section 23(1)'s application to minority institutions, A, unaided, B, aided, in the context of Article 29(2) and Article 21A, that was not the question. There were only 2 questions before Pramati. One was validity of 15(5), the other was validity of 21A. Those are the only 2 questions. Which brings me now, I just wanted to stitch this up. 29(2) specifically deals with aided institutions and says you can't discriminate on grounds A, B, C. It is not a fetter on unaided institutions discriminating. Unaided minority institutions are permitted to discriminate by virtue of 29(2) applying only to aided minority institutions. Therefore, it is possible to argue that society was right when it said that only unaided will be outside but not aided. Could be possible to argue. But that has been overruled by Pramati. Secondly, both 21A and 15(5) came into the constitution by the same amendment, the 93rd amendment. Both. The reason why I'm mentioning that is, if minority institutions had upon them the duty of having free and compulsory education to be provided, as provided under 21A, and further extended by the RTE Act, the words notwithstanding Article 29B would have found itself at the beginning of Article 21A. Because it does find itself in 15(4). In 15(5), they specifically refer to exclusion of minority institutions. May I just read that? Because they came at the same time. Parliament, especially in its constituent power, was, I think, grimly aware of the kind of institutions that the Constitution covers. 15(4) for a minute. 15(4) says nothing in this article. 15(4) was there just after, it's part of the First Amendment. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially educationally backward class of citizens or for SCs and STs. 5 says nothing in this article or in subclause G of Article 1 of Clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially and educationally backward class of citizens or for SCs or STs, insofar as such provision relates to their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30. So in both 15(4), when they refer to 29(2), and here when they refer to Article 30, they're consciously aware that I have to insert these words to get over the hurdles that 29 and 30 pose to me. So when we read Article 21A,
No, but yes, but only issue is, and therefore we pointed out this to Mr. Chaco also.
yes, Manoj.
This may be referring 15.5 is in all probability referring to this educationally backward classes of citizens of the majority community. I can understand of the majority community, they're saying that it will be subject to Article 30.
Yes,
Because then you change the character of that institution.
correct.
But within that minority community itself, if you were to say that you will have 25% backward, how will that change the character of 30 or take or rob away the protection under 30?
It's a constitutional argument. So constitutional argument would be that if that were meant to be done, you would have specifically said so in the first few words of 21A, just as you've done with 15.
No, not
Because the
fact.
positioning that it's with 21 shouldn't.
Now, what is the reason for which 12(1)(c) is held to be ultra-wise? That it will abrogate the minority character if people
Yes.
from
Not
non-minority community.
Correct.
But on the last condition, we have put it to council.
Yes.
Then what happens if it is identified
Within
class
the minority.
within the minority? How can you say that our 12(1)(c) is abrogating the right?
So this is a direct question against the main part of Pramati also. So
Main part of
because-
Pramati.
Because Pramati starts from the
Pramati
basis
could have
that-
read down,
Yes,
could have read down
yes,
2009 Act
yes.
and said that non-minority children, they may not be admitted.
Factually, from what I understand, at least as far as our schools are concerned, that's never been an issue. It's majorly the EWS who are coming in. Apart from that, we give them food, we give them.
No. They are not on any particular institution.
Yes.
They are on the position of law. How could this position be countered by?
But the only thing is, then we have to do a very, I think, creative reading down, much more than was done in society. Because that reading down
No. In
requires.
society also, this part has not been considered.
No, it's not. No, but
Subject to correction, he has not been shown.
Lordship, correct. It's not. But I'm saying the creative reading down is when the virus of the section is challenged, for the court to step in and say, no, we will include unaided minority institutions, but impose on them a stipulation that it will be minority students who are EWS. Well, then you're carving out even 21A.
No, that means
Whether the court can have that.
you're saving the standard from being declared ultra-wise.
No, I'm sorry, Manoj. Let me reframe that.
It's slightly more nuanced.
Yes.
See, ultimately, the intent of Article 21A is to promote universal education.
Yes.
Even if you take up some burden
Yes.
of the state, maybe in the context of minority students itself,
Yes.
that also will be a huge burden.
I agree.
See,
I'm saying
what is the objective that we are trying to achieve? We're trying to achieve the objective of free elementary education
Correct.
for all children.
That I agree.
So once you see it from the perspective of the child,
Yes.
you will have to ensure that each and every child gets educated. And what can be better if it belongs to a minority community studying in a minority school?
I agree, but here's the problem. If in Sardar Patel school, which is here in Delhi,
Yes.
if a Malayali goes and knocks on the door and they say, sorry, we're allowing only Gujaratis in,
Yes.
are we not creating a situation where that Malayali child can
No.
go to court and say my 21A is being violated?
No. Then it will be only, suppose the school is promoting Kannada language or Gujarati language.
Correct.
Then it will be only Gujaratis. You will find EWS even in Gujarati.
But what I'm
It's
saying,
not that you will not find EWS in Gujarati.
no, Manoj, I'm saying, I think the obviously all our motivations are clear. We want to have the children get the best.
Yes.
But
Is our time
But
already?
I'm saying, are we somewhere treading onto the toes of policy
Yeah.
by saying that your Article 21A right, with which a equally minority child in this city will have, is stopped at the doors of the minority institution, where you say no, it's only for that minority, not for this minority.
No. That minority student can even assert a right against the state.
Yes,
He
he
can.
it's my neighborhood school.
If he
He
says,
said 12(1)(c) applies.
if he wants to go, suppose he says, no, I only want to study in St. Columbus.
Yes,
Can St. Columbus deny it?
but provided
Provided to follow.
but if you insist that it's only Christian EWS who will go there, that becomes a problem.
Why? He's a Christian EWS.
Yes.
He wants to study in St. Columbus.
Correct.
He must study there. Why should he not be given preference over there in the EWS category?
The problem is this, that
Huh.
if you are insisting on a sprinkling as Ahmedabad St. Xavier's calls for, I as an institution am providing this
That is for the
sprinkling.
majority community.
Correct.
Sprinkling is of the majority community.
Sprinkling is of the non-minority.
No, but we are talking about minority only. A
Yes.
Christian a Christian young boy
Yes.
wants to study
Correct.
in St. Columbus, he belongs to the EWS category.
Correct.
There will be a reservation for him in Columbus.
Correct. There's no
That is
problem
not
with that.
foul of
But
21.
that can't be read into this act, is what I'm saying. The
Why?
minute your lordships are creating a fifth category in section 12 then.
Right?
You're creating a category of minority schools which are not open to all children of the neighborhood,
Yeah.
but only to minority children of the neighborhood.
What difference will it make? As long
Because
as
if the-
minority.
No, because if the onus is to serve children,
Yes.
then serve all children.
No,
You
sir.
can't make the distinction
Sorry.
in the act.
The act itself makes a distinction that it's only for EWS.
Correct.
25%.
Correct. Which is why we're saying EWS plus minority now.
So
That's
EWS.
the problem. I'm saying that the act doesn't consider.
EWS of your community.
No, Balaj, what I'm saying is that what the courts will do? Will that parliament have to amend
No, why
and bring
not?
in a file?
Why not? No, ultimately we are giving say wings to what the parliament thought, that the EWS community will be accommodated in all schools.
Yes.
Ultimately, what is the state saying in this? See, our resources are limited. Each and every school must come forward and join this endeavor of ours to ensure universal elementary education.
That's good.
That's what the state is saying.
That's good.
And we will help you to up to a certain extent. We will reimburse certain amount of fees.
Correct.
But all institutions are to join in that endeavor. Even the minorities. What has happened today is we have created an island whereby the minority institutions are outside this endeavor. At least they may be doing it voluntarily, but they are not bound.
They're not bound. That's correct. They're not
That's
bound.
the endeavor. Bring them in.
Yes.
This endeavor. See, it's a very noble endeavor.
No doubt. No doubt.
I think this
I
is not
just
a-
wish they had drafted their provisions of amendment better. There would have been no problem.
maybe.
If there are any creases, who is to iron it out?
Let's resolve it.
As
See,
much-
let them also join the movement. The problem is everyone must join this movement. I am sure they must be doing it on their own, like you are saying. But let them also join the movement.
saying
Let
there
them
must
not be
be-
seen as an island. You know,
Yes. No, your lordship is right.
why should they be an island?
There should
They
be a
must join
statutory
this endeavor.
mandate which takes this forward.
Why not take it forward? If there is an issue, we can, as my brother says, iron out the creases and bring them in. This is a great endeavor by the state. And everyone must join in. And if in fact, the minority institutions themselves volunteer that we will do it, and they're doing it. But we know it in Delhi, at least I know it in Delhi, that they're doing it.
Yeah.
So there's no problem. Why don't they join the endeavor?
The problem is eventually.
Why convey an impression that we are outside the ambit of this?
No, that's absolutely true. But we have gone very far away from where this issue arose, which was only 23 and laying down standards for teachers. So
No. But now we are asking, now that we are
Yes,
considering all this act of all, why not?
I'm saying because
Why not correct the impression? Why not bring them in the fold? Why not ensure that it's a national endeavor? It is a national endeavor.
even that can't be done voluntarily. A school can't say.
No, maybe not. But then we are saying if we pass the
Once
judgment,
once you have a constitutional bench judgment for right or wrong which says that the act doesn't
Yes.
apply, then minority institutions.
If the person coming from the EWS is unable to pay your fees,
Yes.
it's the government who will pay it.
Yes.
But he belongs to your community, therefore there is no abrogation.
Yes.
So from this perspective, Pramati has not seen the problem. This is what we intend to convey to you.
No, your lordship.
It's not that we would be laying down the law again.
No, that's clear.
We can't
It's
because of this.
Yes.
But these are questions to be formulated for answer.
Your lordships may formulate that and consider these three questions which are placed also. Because eventually, Malaj, once if seven were at some point to hear this, it would be a good guiding line as to what those points are that you're. No. Huh?
Because much of the effort of Parliament
Yes.
has been frustrated.
Yes.
After this Pramati was 2014,
Yes.
10 years down the line,
Yes.
segment is getting the benefit, the other segment doesn't get the benefit.
That's right. I mean, the benefits of the schools existing.
Children, nothing more. There's nothing in our mind other than children of 6 to 14.
That's
Right? Yes, Mr. Natak.
I have one last solution.
Huh? If you have any other questions which you would like us to consider for framing, you
Will
will-
submit. I believe since this is arising from a 23 context, if your lordship, I consider limiting it to the 23 issue and whether it applies or does
No,
not.
not only 23, other parts.
No,
Then part
allow me to say, the others, we've placed in the same volume the Tamil Nadu Act as well. All these state acts deal with all these issues. They have rules under them which deal with all of them. So all of this is dealt with, it's been dealt with. It's not like before the RTE Act came, ragging was permitted, all these fees could be imposed, etc. All of that, there are provisions in all the state acts. Tamil Nadu is very detailed, the second act which has come, there are rules under it. So it's not really an issue with any of those, including the registration, recognition, provisions for the derecognition, stricter standards with reference to.
What will happen is each state
Yes.
will then be laying down different standards.
But they do this under RTA also. Each of them have RTA rules for the separate states. So apart from the minimum standards, other standards are laid down as they go on.
NCT when NCT lays down standards must be complied with by all.
NCT is yes, but
No problem.
that's only academic standards, bro. The others, facilities, etc., etc.
Admission of student registered as well.
I just placed those additional questions, but this your lordship may consider because I really feel that the confusion. There's no reconciliation on this point on these three questions on how to refer and in what circumstances. I do believe there's a 145(3) question squarely here. It does exist. So if then it goes
My
directly.
only problem in this case is, as my brother pointed out, that the constitutional bench has already spoken
On those two questions
on those two questions.
only,
Ah.
but not on other questions. So
No,
other questions are raising now.
in fact, in our view, they have spoken so broadly that
Yes,
without
that's true. That's
examining that aspect, they have spoken.
correct. But I would. My only suggestion is please don't follow what Islamic and Inamdar did in trying to clarify one para. I think they should just go to a larger bench if the lordships are inclined to. I'm grateful.
One suggestion regarding the question as to whether Millard, other questions can be referred to. Could your lordship kindly have a look at para 12 of this judgment, Millard? Where, Millard, when the matter is referred to a constitutional bench, the question was, Millard, whether questions which was not an issue before the court can be referred to a larger bench, Millard. Insofar as your lordship is concerned, Millard, the only question is section 23. Then, Millard, it may be open to your lordship to refer it, but not other questions. Millard. Kindly see para 12. Millard. Para 12. Reference of a case to a larger bench necessarily has to be for a reconsideration of the principle of law on which the case has been decided, not in merits of the decision. The decision rendered by any bench is final inter partes subject to the power of review and the curative power. Any other power would have the effect of conferring some kind of an appellate power in a larger bench of this court, which cannot be countenanced. However, the principle of law on which the decision is based is open to reconsideration by a larger bench in an appropriate case. It is from the aforesaid perspective that the reference in Yansing is to be understood, namely whether causing of a non-commutable, etc., etc. Therefore, Millard, in fact, Millard, 12 is not the subject matter of consideration before this court. Large number of people may be affected by it. They are not before your lordship, Millard. The only people who are before your lordship are the people who might be affected by the application of section 23. In fact, perhaps Millard, 23 may require consideration, Millard. Therefore, my submission is, Millard, please confine to 23, if at all your lordship is referring it. Other questions were not before your lordship, Millard. It was not before Madras High Court, Millard, nor it was not before Bombay High Court also, Millard. So my submission is, Millard, if at all it arises, yes, Millard.
The problem that is happening over here is, even for 23, we have to overcome certain observations made by
Your lordship, that can be done.
No, that the observation is a very broad observation and a broad finding.
Millard,
That the Act 2009 does not apply to minority
Millard, yes, Millard.
and therefore we have to point out
I will tell you what.
why we are doubting that observation.
No.
Those are the various facets on which we are doubting it.
That may arise in an appropriate case. But in so far as this case is concerned, Millard, it is only application section 23. Nothing else, Millard. And there are a large number of people who might be affected.
Even the issue of 23 by doubting that observation that the whole Act does not apply to minority institutions.
No, Millard.
And then we say that we have seen in the judgment, it is primarily in the context of 12(1)(c), and that too we feel it has not examined that contour of 12(1)(c).
I will tell you, Lordship, Millard, why, Millard, that arose. Millard, I'm sorry that I'm reiterating.
No.
Millard, that is because, Millard, 21A is very clear. Free and a law for the purpose of implementing free and compulsory education. And 15(5) says it cannot take in minorities. Both put together, Millard, it can't be applied. It is in that context, Millard, Pramati has said, the entire Act goes. It cannot apply to minorities. Now, insofar as the other aspect, Millard, para 65 of society.
Mr.
Yes.
If that observation is not doubted by us, that the whole act does not apply to minority issue. How do we deal with section 20? Even with regard to section 20, we will have to doubt that. In that context, once we doubt that,
Then we have a lot. No, my lord, I tell your lordship. I tell your lordship.
everything will get
Yes,
doubted.
I tell your lordship, my lord. Then your lordship can say, insofar as 12 is concerned, Paramati may be justified. When insofar as other provisions are concerned, well,
That is
that, my lord, there is no need to reopen 12, my lord. That has already been considered. In fact, my
But
lord,
12 facet has not been considered whether there can be a reservation only for minorities.
that, my lord, I told your lordship, my lord, because of 15.5. Because your lordships are keeping in mind only 21A. But your lordship may
They
keep
are
in
also
mind.
keeping in mind 15.5.
That's right.
We see 15.5 is
Yes.
talking about reservation for economically backward and scheduled caste.
Yes, yes.
But that is talking about from the general community.
No, it is not.
When it
No,
is
it does
talking-
not. It does not make any difference with the general community.
That's what we are saying.
Yes.
Why not a distinction be made? That is talking only about so that you do not lose your minority character. What is the intent of it? Your minority character should be preserved. Right?
Yes.
Now, if you get minority students only from the EWS category, you will join the movement also of universal elementary education. You will also become a part of Article 21A, but at the same time, your Article 30 is protected. Your right to be preserved under 30.
Your lordship made
At
a
the same
mention
time, you
about.
bear the burden
Yes.
of taking this country forward. I think we all institutions have to bear that burden.
They
Even
are.
in your community, even in the minority community,
Yes, sir.
there are a large number of EWS students who cannot afford to get
They are all.
educated.
They are all taken care of. They are all taken. In fact, and it is paid from the pocket of the institution. Today, it will become a portion of it will come from the pocket of the state, beloved. It will be. It may become a huge burden for the state also, beloved. Possibly it is because of that, beloved. Learned AG had some reservations about it, beloved. Whatever it may be, beloved. My respectful submission before your lordship is it's only interpretation of para 55. I mean that para 55, beloved. In which case, beloved, it is not necessary that the matter has to go before a larger bench, because as rightly did by this honorable court in Inamdar and Islamic, beloved, it can go before any bench. 3 judges, beloved. As your lordship said, beloved, it may perhaps, beloved, there is no necessity to say it should go before a larger bench. I mean, 5 judges or 7 judges, beloved. It may be made open, beloved. And that too, beloved, it cannot affect section 12, beloved. Maybe other provisions, perhaps, beloved, may require. I leave it to your lordship. Now, beloved, with respect to 65, beloved, para 65 of society, beloved, your lordship is right. It was actually rendered in the context of severing unaided minority institutions from the RT Act. It is in that context, but I still remember I was assisting Mr. Andhyarjuna in this particular case. So after arguing for unaided minorities, Mr. Andhyarjuna placed before the court the way in which it can be done is this: the applicability of RT Act to unaided minority institutions can be severed by applying the doctrine of severability. Your lordship is right. I remember that. Right.
According to me, there is no other way.
I
Otherwise, the whole RTE Act would have fallen forward. That's the only way to save the RTE.
So Chakol, this para 12,
Yes, ma'am.
I'm posing a problem for you.
Yes, ma'am.
Answer in the light of this. The 3-judge bench has held decision rendered by any bench is final inter parties, subject to the power of review and curability. Absolutely correct. But this next
Your lordship is
sentence,
reading which paragraph?
para 12, which you just
Yes.
Gopakumar,
Yes.
para
Yes,
12.
yes, ma'am.
Any other view would have the effect of conferring some kind of an appellate power in a larger bench of this court,
Yes,
which cannot be countenanced.
yes, ma'am.
Right. Now, let us assume comes before this court in an appeal, say from NCTRC or some other commission. It's a civil appeal
Yes.
that is registered between A and B, and the appeal is dismissed. So there is a merger of the NCTRC order,
Yes,
right?
yes, ma'am.
Now, the NCTRC order affects a third party who was not a respondent before the NCTRC. He seeks permission to file an appeal here in this court. And the court finds that yes, they are the genuine grievance. The order of the NCTRC affects him. But the person who got the favorable order from the NCTRC urges the court that look here, merger has happened. You cannot sit in appeal over the order of the NCTRC because it does not exist. It has merged in the Supreme Court order. What does the Supreme Court do with this appeal? Remember, Supreme Court is of the opinion that injustice has been done here. Then, of course, the matter has to be referred to a larger bench and they will sit in appeal.
But Millard, here,
So therefore, it's very difficult to make certain observations keeping in mind the facts of one particular case. These all have to be read as confined to the facts of this case.
correct. I'm only saying.
Otherwise, we will be
I will tell you, Lord.
in a very difficult situation if we have to go by this
No, Millard, I'll tell you, Lord.
dictum.
Why I said so, Millard, because if, Millard, the whole thing is going to be reopened, Millard, there are a large number of affected parties. None of them are actually before your Lordship, Millard.
No,
Therefore,
we are not deciding anything.
yes,
We are not going to decide anything on this point. It's only a reference before the larger bench or the Chief Justice or a three-judge bench. We'll now have to decide whether we refer it to a three-judge bench, whether we say it should be placed before a file, or we say simply that the Chief Justice should look in. Thereafter, if it is referred, those large number of parties who might be affected, they can always join. But as it stands, 55 of Promati,
50, that's what I'm
it's
saying.
difficult for us to.
Correct, Millard. Your Lordship's difficulty, I understand, Millard. Section 12 and other provisions of the Act. So, therefore, Millard, not necessary that Section 12 also should go along with it, Millard.
No,
That's all.
well, this other point is also there. UWS within the community.
That, Millard,
That has to be-
Millard,
that has to be-
that, Millard,
has to be.
that is in the context of 15.5.
That has to be. Yes, Mr. Nataraj. You've been waiting for quite some
No,
time.
no, it's a pleasure to be part of the healthy debate which is going on a particular legal issue.
Sure. Those who would, we would call upon you to give you a written
Yes,
notice
Millard, I'll do.
in a pen drive.
Yes, I'll do that.
Those are
Yes.
soft copies.
Yes.
Otherwise, our
I'll give it.
we just
Yes,
can't be
sure.
here. What will they tie, you know?
Yes.
Give it on a pen drive so that we can
I'll give
use.
Yes.
It's on behalf of Union of India, I mean, all these legal issues and making submissions. Since various documents and provisions have already been placed before this noble court in the, by predecessors in the matter, I do not want to get into all these aspects of the matter. So straight away I'll go into 3 or 4 the issues which may call for consideration in the matter and to elaborate argument only on that aspect without touching any of actual aspects. So basically in the context of the issue before us on the court,
We have a written note.
written note I'll give it later. Judgments I have made a compilation.
That is.
Separate agencies.
Written note you give later.
I'll give that later. Now, the first issue would be whether the eligibility criteria is applicable to all institutions, irrespective of nature of institution, whether it's a majority or minority.
What do you mean by eligibility?
Eligibility criteria fixed by the NCT.
Acha, that is
Yes.
23.
Yes.
Minimum qualification.
Minimum qualification.
So whether minimum qualification.
Whether minimum qualification?
Laid down by NCT
NCT
would be applicable to institutions across the board.
across the board.
Yes.
The incidental issue would be whether it applies to promotions also.
Yes.
Third one would be the effect of para 55 of Pramati's judgment, how that has to be construed and interpreted. The fourth one would be the consequences. By assuming that the eligibility criteria or the requirement of section 23 is indispensable, then what should happen to the teachers who have been appointed and what should be the effect of these issues?
Consequence of non-compliance of minimum qualification.
Absolutely, please. Before elaborating the arguments on these issues, on the first issue, the stand is that eligibility criteria or the requirement of the
TET.
yes, TET. That's irrespective of nature of institution, it is indispensable and non-negotiable. On the second issue, it equally applies to promotions also. Third one, with regard to Pramati para 55 is concerned, that does not lay down the ratio or the binding precedent to say that the act is kept out of the purview of the act insofar as minority institutions, insofar as eligibility is concerned.
May not be the ratio, but it's the answer to the question.
That is, yes, that is the crux of the matter I'm pointing out. In the particular case, how that has to be read, omitted. And various principles, which fit like by applying the principles of inversion, which I point out in the reference to that. Yes, I'll come to it. Yes. And the fourth one, I may have to answer on facts at the end of the conclusion of the argument. Depends upon the view this one court is going to take and how to come out of the situation. These are the answers with regard to the book. Now let me elaborate on the first issue. Already a couple of judgments right from the TMFI case and various other citations have been cited, where there is a categorical pronouncement that in respect of these kind of activities, prescribing the eligibility criteria for admissions or the grant of recognition, or there is no question of whether it's a minority or majority. Apart from the judgments which I have cited, without elaborating much, there are two more judgments which I'd like to place. That is, number one is 2007, Volume 1, SCC 386. That's the first judgment in the comparative.
What is the next judgment? The citation.
Yes, 2007 1 SC6 386.
First.
Yeah, first. The second one is 2020 Volume 8 SCC 705.
705.
Yes, that's on the first proposition. Two more judgments. Now, can you take the first judgment? Paras 19, 20, and 21. In para 19, they refer to TMFI. Then kindly go to, because it's again the reproduction of TMFI, kindly go to para 20. I'm reading para 20. Aided institutions give instructions either in secular education or professional education. Religious education is barred in educational institutions maintained out of the state funds. These aided education minority institutions providing secular education or professional education should necessarily have standards comparable with non-minority educational institutions. Such standards can be attained and maintained only by having a well-qualified professional teachers. An institution can have the services of good qualified professional teachers only if the conditions of service ensure security, contentment, and decent living standards. That is why the state can regulate the service conditions of the employees of the minority educational institutions to ensure quality of education. Consequently, any law intended to regulate the service conditions of employees of educational institutions will apply to minority institutions also, provided that such law does not interfere with the overall administrative control of the management over the staff. Then again, para 21. We may also recapitulate the extent of regulations by the state permissible in respect of employees of minority institutions receiving the aid from the state as clarified so and so, so and so, para prescribed prescribed from PMFI. In other words, all laws made by the state to regulate the administration of educational institutions and granting aid will apply to minority educational institutions also. But if any such regulation interferes with the overall administrative control by the management over the staff or abridges or dilutes in any other manner the right to establish and administer so and so such regulation to that extent will be inapplicable to minority institutions. So in order to maintain the standard in the education, such conditions, it's always permissible to prescribe. Quality of education is paramount consideration. It is the essence of the constitutional requirement which cannot be compromised. This is the first one. The next one is 2020, Volume 8 SCC, that is with reference to uniform NEET issue.
Uniform?
Uniform NEET, where uniform NEET was prescribed. This para 65 to 67 are relevant paras, which are it's a lengthy judgment, so rest of the page 120 is compilation. 122. By the three judges in the context of common need. Thus, we are of the opinion that rights under Article 19(1)(g) and 30, read with 25, 26, and 29, 1 of the Constitution of India, do not come in the way of securing transparency and recognition of merits in the matter of admissions. It is open to regulate the course of study, qualifications for ensuring educational standards. It is open to imposing reasonable restrictions in the national and public interest. The rights under Article 91(g) are not absolute and are subject to reasonable restrictions in the interest of the students' community to promote merit, recognition of excellence, and to curb the malpractices. Uniform entrance test qualifies the test of proportionality and is reasonable. The same is intended to check several malafies which crept into medical education to prevent capitation fee by admitting students which are lower in merit and to prevent exploitation so and so. the institution has to be capable of education. The minority institutions are equally bound to comply with the conditions imposed under the relevant acts and regulation to enjoy affiliation and recognition, which apply to all institutions. In case they have to impart education, they are bound to comply with the conditions which are equally applicable to all. The regulations are necessary and they are not divisive and disintegrative. Such regulatory measures enable institutions to administer them efficiently. There is no right given to maladminister the education derogatory to the national interest. The quality of medical education is imperative to subserve the national interest and is also. The government has the right for providing regulatory measures that are in the national interest, more so in Article 19(6) of the Constitution, then paragraph 66. The rights of the religious linguistic minorities under Article 30 are not in conflict with other parts of the Constitution. Balancing the right is the constitutional intent in the national and more enormous public interest. Regulatory measures cannot be said to be exceeding the concept of limited governance. The regulatory measures in question are for the improvement of the general health. It's a step in furtherance with the directive principles enshrined under Article 47 and 51J and enable the individual by providing full opportunity in pursuit of the objective to excel in pursuit. The rights to administer institution under Article 30 of the Constitution are not above law and other constitutional provisions. Reasonable regulatory measures can be provided without violating such rights available under Article 30 of the Constitution to administer an institution. Professional education institutions constitute a class by themselves. Specific measures to make administration of such transparent can be imposed. The rights available so that in reference to the may not be much relevant in the same para. Then finally in para 67, recently so commonly TET it is. So to achieve or to maintain education standards, which starts from the first standard or the which is now guaranteed under Article 21A. So by applying that Article 21A and also the principle which says that ultimately there is a quality of education which is more important. And every child has a fundamental right to get such a quality education. And to right to get such a quality education does not depend upon the nature of institution, that is whether it's a minority or majority.
Yes.
A student studying in a minority institution